Dear students, good morning and welcome to the Industrial Property Law course. So that would be HOE 6065. And well, I'll be talking about trademarks today. So as I informed you last week in the introductory lecture, the introductory video lecture, that I'll be handling this course in this term. So, well, we'll be looking at some of the key elements that comprise of industrial property, and then of course the most important one here that we'll be talking about is trademarks. So we'll be spending about the next 4 or 5 weeks looking at different elements of trademark law. And since we are in the European Union, of course the main focus would be on the directive. And if you see in the Moodle course, you'll also notice that the directive is up along with a lot of other information. So that's going to be more or less the agenda for February. And we'll look at various issues purely from a legal viewpoint, of course. I'll also try to bring in some elements of my experience in this field. Well, I finished my law studies in 1998, and then I started working in a law firm, and the partner I was working for specialized in IP law, and of course, trademarks was a huge area. So, well, I did the whole thing, trademarks filing, trademarks in the trademark office, the entire process, then litigation in the courts, assignments, whatever, everything possible. And being a young lawyer, I did everything wrong the first time, spectacularly wrong. But of course, as a lawyer, you all make mistakes. We all do. I mean, you can't avoid making mistakes. If you don't want to make mistakes, then that basically means you don't have to work. Because if you do any work, there will be a strong chance that you will make a mistake. And the only trick is to make sure that number one, you rise after every fall. Number two, you learn from the mistake. And number three, you don't repeat the same mistake in the future. All right. In the future, you make a new mistake. And that's a part of the learning process. Nobody gets fired or anything for such things, unless it's a spectacular mistake. But there are a lot of safety mechanisms in the entire litigation process, in a court process, in a law firm. It's an institution, all right, and there is institutional bias, there is institutional lethargy in a way. You also have all sorts of aspects, institutional inertia, for example. So it all takes time. Nothing happens overnight, and so you don't have to be worried. As a young lawyer, for the first, I think, 4 or 5 years, you're just learning and making mistakes and learning every time. Now, I know a lot of law students who, after law studies, never go to a law firm to work. I mean, they just go straight to a company or in a government office or department or whatever. And that's a little weird because, if you want to be a lawyer, you need to be in a law firm to experience how litigation works and how things work, because that's very important. At least personally, that's what I feel. It's something that gives you an edge because you realize when you are in the deep part of the lake, that you have to swim or else you will sink. So I really can't understand lawyers who have never been to a court of law. But again, that's my own personal view about these things. But if possible, give it a shot, at least a year or two, if not more, in a law firm. I worked for almost, I think, 9 years. Yeah, so I learned a lot over there. Now, looking at industrial property, if you may recollect, I spoke last time. So we have intellectual property law, and this comprises of industrial property and then copyright. Yeah. So what is industrial property? Trademarks, patents, designs, stuff like that. What we'll be learning here. And what is the other stuff that's left out? Well, that would be copyright. All right. So it's very important to remember what are the key differences between the different types of, industrial property or general IP law, and so intellectual property as well. So we look at some of the key elements here. Now, number one would be a trademark, and if we look at it from just a simplistic viewpoint, what does this IP comprise of? and what is the monopoly period. Yeah, because all intellectual property gives you a monopoly, and that's how you make money, hopefully. If you get a monopoly by the state, it means only you can exercise this right and nobody else can. So let's say a trademark. Yeah, so you have a trademark. It could be Mercedes, could be Yahoo, Facebook, yeah, could be I don't know, Stockman, could be Microsoft, Google, yeah, whatever. Yeah, so these are all trademarks, and some are very inventive. Google never existed before as a word in the English language or any other language, and so you incorporate it into a trademark. Others could be, for example, Yahoo. Yahoo doesn't really mean anything, although in Gulliver's Travels, there's this old book, storybook from 200 years ago. There's this sailor who keeps on going on ships and getting shipwrecked and landing in all weird places. So once he lands up in the land of the giants, then once he lands up in the land of the Lilliputs, the small guys. So there are different stories, and in one of the stories, again he's on a ship and the ship sinks. Yeah, he's a bad omen for the shipping industry. Anyway, so Mr. Gulliver wakes up and now he's on an island which is inhabited by very smart, intelligent horses that can talk, and these horses have human slaves called yahoos. Yeah, again, what I'm trying to say here is that you take a word, a random word like Yahoo or Apple or whatever, and then you turn it into a trademark. And of course, there are certain ways to deal with this legally speaking. And then of course, you have a word which is just combination of somebody's name or whatever. All right. And then you can have something like Finnair, Lufthansa, so all of these are different types of trademarks. You could also have some label marks. You could have Tallinn University of Technology was quite a problem because it's Tallinn University of Technology. There's nothing special about these words, but you put them together, and now they rebranded it and call it Taltech. So all of these are different forms of trademarks. But the point here is, a trademark is not rocket science. All right, you just need to find something catchy, and that's good enough. I mean, you spend money on publicities, marketing, all that stuff, and it becomes popular. All right, so you have Apple as a trademark. It's a half-eaten apple, or not half, but maybe 1/10 eaten apple. So that's the logo, and you see that on the iPhone or whatever, and that's it. What does it mean? Anything. Could be whatever you want your imagination to be. It could be the apple that fell on Newton's head. Yeah, it could be whatever. It's whatever it is. It's not an eating or eatable product. Yeah, it's a electronics company, software company. So of course, the bottom line here is a trademark is just a word you pick up, or a logo, or a combination of words or logos or colors or layout, get up, color scheme, whatever, right? So you do that, and that's your trademark. So you don't really need to be a Nobel Science laureate for that, all right? It's just something basic. If you're good at marketing, you're good at picking up a trademark. And of course, a monopoly for a trademark, well, almost all over the world now. And this is important to keep in mind because intellectual property laws have been, synchronized throughout the world. And this has been going on for a long time. So now IP laws all over the world are more or less the same because of the United Nations, the World Intellectual Property Organization, then the TRIPS agreement, which was signed in 1994. So for a long time now, IP laws all over the world are quite similar. Doesn't matter whether you're in Estonia, Finland, Germany, outside the EU, USA, Russia, India, South Africa, China, whatever, doesn't matter. Maybe only North Korea or something may be left out, but otherwise IP laws are the same. So when we talk about IP law or trademarks law and we talk about the directive, remember it's the same more or less throughout the world. And so when we look at monopolies, well, for a trademark, if you get a trademark registered in the trademark office, which is a government organization, and then you get it registered, and then it is for 10 years, and you can keep on renewing it after every 10 years. So you have some trademarks like Beretta is this Italian weapons company, and they've been around since the 1500s. Yeah. Coca-Cola has been around for more than 100 years. So you can have companies that are around, businesses that are around, and so a trademark could be for almost forever, as long as civilization and IP law lasts. So in that sense, these are two important elements to keep in mind. Trademark, simple to figure out, and although of course that's not always that easy, because I've been involved with businesses, and then the worst thing is trying to figure out what would be a good trademark, and what could be the good name for a company or something. It's like choosing the name of your child. Yeah, these things you can't change just because you want to. It can be very expensive for a company to change a trademark or its trade name or corporate name or trading style or whatever you call it. And the monopoly period is almost forever. Then we compare that with patents. Yeah, patents are very technology oriented, and it's a technical solution to a technical problem. That's the key. We learn about patents in more detail as well. So of course you need to have a good idea about patents. Yeah, patents don't happen overnight. So for example, if you were to look at you wanted light, this would be how you get a light. This is a candle, all right, and then so you put a candle on, and so you get the light, and that's how life would have been in the past. But then of course it has some issues as an invention, because if it's windy, it's wet, it's raining, candle won't work, and the light isn't very intense, if you could call it so. If you need more light, basically you need more candles. Yeah. And so there are a lot of restrictions to that. So the technical problem would be, how could you have a candle or a source of light which is better than a candle? So you want a source of light, and it should be able to withstand a lot of issues. You don't need a matchstick for it. It should be easy to operate, and it should be bright enough to cover for a lot of the previous competition. So you want something that is better than a candle. And so the idea of taking two metal filaments like this, yeah, and you attach them over here. So now there are two elements which are attached to each other, and you form a circuit. All right, electric circuit. So this side is positive, this side is negative, and now you have these two different metal filaments. And now the idea is that when you send electric current racing through it, the filaments get hot. By itself, that may not help so much. But what if you put it within an enclosed container, and it's transparent, so it's like this glass thing, and you make it you induce vacuum into it. I mean, you remove the internal air and atmosphere, so that you have a reasonable amount of vacuum inside, and now suddenly you have a strange phenomena. And that phenomena is that when you put the light on, electricity connection on, because the metal filaments get hot, and because they are within a vacuum environment, they emit light. And it's a special type of filaments, of course, a special type of metal. But obviously you can see the difference between the candle and this light bulb. Yeah. So this is a technical solution to a technical problem, and so of course this would be eligible for a patent. Now this is not in the same category as choosing a name like Victoria's Secret, or a trademark like Hyundai or Toyota or something. This is rocket science. All right. So of course this is a patent, and because it's highbrow, you need to have brains to understand a lot of the aspects, physics, chemistry, whatever that goes with it. And nowadays you have nanotechnology, biotechnology, all the fancy stuff. So of course patents are extremely complicated. Although not necessarily, I'll give you examples when we talk about patent law, maybe in March or sometime. What about the monopoly for a patent? Well, a monopoly for a patent is not unlimited, unlike trademarks, remember? So a patent would be for 20 years from the date of application. Yeah, so that's very important to keep in mind. It's not forever. Although there are some possibilities, if you have drugs or special medicines or something, then pharmaceutical products, inventions for pharmaceutical products, then maybe you could get some extra time. Yeah, and in the US you have the Orphan Medicines Act and things like that. But that's rare, okay, because that comes into a totally different area. It's called evergreening of patents. And that's where IP law and competition law clash, and it's a huge crazy mess up. So that's patents. Then you have designs, and of course designs are quite simple. So in the sense that, well, we live in a world where it's not just about functionality, it's also about looks. So the only things that sell are super sexy or super ugly. Yeah, so you have you have designs which deal with very important elements. I mean, whatever you look, whether you look at your phone, your car, it's called stylish elements, and these are of course relevant in many places. So if you look at different things, you look at your television set, you look at your shoes, there is a functional aspect, of course, but the design feature would comprise of a more elaborate issue, which is how it can be visually appealing to the eyes. We'll talk about designs when we deal with that later on. But design law is a very important element. Of course, you're designing a chair, so you could have a simple chair, all right, and this is now your simple little chair. You sit over here, bum here, back here, four legs, basic. And then you could have a chair which is a bit more fancier. It could be, for example, something like this. And now, it can move up and down, it can swivel, it has wheels, and it has some fancier shape. And then, of course, you have designer chairs. I'll give you an example later on. And of course, as you all know, your simple IKEA chair can cost 80 euros. Yeah, and then your designer chairs could cost maybe 2,000 euros or 10,000 euros or whatever. So that's designs law, and it's not forever, of course. It's 20 or 25 years depending on various schemes. You could have unregistered designs, you could have registered designs. There is an EU regulation for this. So we'll talk about that. So as I hope you understood here, trademarks are for a particular time, are forever. Patents are for a particular time, they are for specific technological inventions, and designs are, well, it's like where an engineer meets a fashion designer. It's a strange mix because it's all about how something looks pleasing to the eye, all right, because there are the same type of phones in the market, the same type of cars in the market, everything is there. A car has four wheels. What can you do to make it attractive? Well, you could make it in a certain shape, and of course, if it's functional, that would be patents law, aerodynamic or whatever. But if it is stylish, like a lot of things that the Italians do, yeah, that would then come under design law. So for example, I'd gone to Venice, good old days, remember when you could travel, and they have these water taxis, and they're so stylish. Yeah, you're like, wow, I mean, you actually feel like James Bond when you are in Venice. I stayed for a few nights, so it's a different feeling altogether. And then, of course, when you are in Italy, you can understand how fashion is important, all right? Because anybody can design a pen like this, but designing something fancy which attracts the attention, which is visually appealing, and that too on an industrial scale, is just not always that straightforward. And we have some examples of this also from Scandinavian designs, Nordic designs and things like that. So we'll look at those in more detail later on. And then of course there is copyright. Well, we are not dealing with copyright law over here. Remember, this is industrial property. But just to let you know, copyright also has some creativity, of course, to it. You're singing a song or you're writing a novel or whatever. And copyright is for 70 years from the year when the author dies. All right, so again, it is limited. So all four of these, and especially from our viewpoint, trademarks, patents, and designs have specific requirements. Now, generally, this was a very clear-cut way, right? Either your invention or your product or your service is under a trademark law or patent law or copyright law. And life is simple, or designs law or whatever. So nothing mixes, no inter-exchange of anything. You have clear-cut boxes, and either you are in a trademark box or a patent box or a design box or whatever. But now come some very important aspects from life. Yeah, what are the important rules for a lawyer? Now these are something I just made up based on my own experience and what I have understood after dealing with other lawyers. So rule number one is learn to bend the law without breaking the law. Very important. Rule number two, don't get caught. Yeah, of course. And rule number three, if somebody goes to prison, make sure it's the client and not you. Well, of course, rule number three is not relevant over here, although I must tell you that IP law, industrial property law, has civil law and criminal law elements. So we'll talk about that later on. But rule number one, learn to bend the law without breaking the law. Now, this is where it gets very tricky because you have to use your brains, and there's a lot of very smart people out there. So how can you do certain things? Well, for example, a trademark is, it can be a word, it can be a sound, it could be a color scheme, and then I'll talk about various examples. There's also in the notes a guest lecture on non-traditional trademarks. So when you look at those, you'll get a good idea about the different types of trademarks. You can even have smell trademarks. All sorts of things are possible now. And the directive was changed in 2015. New directive came in. It came into force from 2019. All the member states of the European Union had 3-4 years to change their laws, make them more in synchronization with the directive, the trademarks directive. So of course, well, now you have a situation where a trademark can be a shape. Yeah, Coca-Cola bottle can be a shape, a trademark. So now let's say you are smart and you want to get maximum protection for your product. Okay, so now let's say you are in the business of making motorcycles. Now, of course, this was much more fun in the classroom because I could show you audio visual stuff and everything, which unfortunately is not possible here. There are quite a few limitations, but we try to overcome them with my personality. All right, so let's say you are a motorcycle manufacturer. All right, what is it in, oh yeah, very good. Okay, so you make a motorcycle product, and just like many others. So this was especially true with the Harley Davidson case, and it was quite a smart way of looking at things. So, the main thing about the motorcycle is the engine and the various things that the engine does. So let's presume this is an engine, all right, and from inside, and it's 2-stroke engine, or you could have a 5-stroke, 6-stroke, I don't know, 25-stroke engine or whatever, and it gives maybe 100 horsepower or whatever. All right. So of course this is now purely technical, so it should come under patent law. And if it comes under patent law, well, you know what that means. That means that your patent, if it's a technical solution for a technical problem, and of course the patent law criteria is very, very strict. and very very difficult to overcome. So it's not like anybody can get a patent. You really need to have a science input into it. So of course, you could have this situation where you get a patent for this invention, and it's going to be for 20 years from the date of application. But now you know from the definition of a trademark, or you'll be learning this, that you can get a trademark registered for a sound. Yeah. Now, those of you who know about motorcycles or have seen motorcycles, I presume all of you, you know that they can be quite noisy, but it's not always that simple. Sometimes, they can have different types of noises. So maybe I'll just show you, or you can hear a noise. And well, this is what actually Harley Davidson tried to do. So, well, we will show you the noise. I'll play the video and you can hear the noise. Yeah. So Harley Davidson motorcycle sound. All right. So Harley Davidson actually tried to get this thing, this exhaust sound of the Harley Davidson motorcycle registered as a trademark. Okay, let's see. Could you hear this?
Skip this ad, just like you skipped out on buying Amazon stock and Google and Apple.
Okay. All right, so basically what Harley Davidson was trying to say is that this is a particular special noise. It comes from our special Harley Davidson engine, and so it should be registered as a trademark. And everybody thought it's funny. Of course, this was opposed and it didn't go through. But this is a smart way of looking at things here, right? You could apply for a patent, 20 years, or you could apply for the trademark for that noise that comes from the exhaust, and then of course claim that this is a special noise that comes from a special type of engine. And what you're doing now is you are putting the competition in a very peculiar situation, because they can't make an engine. I mean, if you get a trademark for the noise, then their competitors cannot make an engine which would make a similar noise. Yeah. So you see how this thing plays out. And of course, as a lawyer, you have to think out of the box. You have to be able to bend the law without breaking the law and things like that. All right. So anyways, we continue here. So there's a European Union Trademarks Directive, and that's going to be the key focus area. 2436 of 2015. So it's in the Moodle notes. And of course, as lawyers, well, you need to know this directive really well, inside out. Yeah. And of course that's very essential, because otherwise this course will not make sense. So of course you can look at the directive, and like all directives, it has the recital, which basically talks about the background and then what things are, how they were, what are the challenges that have occurred or arisen. Now remember, there was earlier a directive from 1995. Yeah, and of course, this was a very long-lasting directive, and it dealt with a lot of things. And the only weird aspect was that society doesn't stay still. Technologies change and society changes, and so the old directive from the 1990s was no longer relevant, because of so many new case laws and decisions and newer viewpoints and things like that. So it's very normal that the law changes after a few years or decades, and you don't want to be stuck with a 200-year-old law, unless it's a very good law, which can be quite problematic, because as you know, in today's world, so many things change, and as lawyers or law students, it's always a huge challenge how to deal with these changes. Like for example, you have the law of contract. and or some law which talks in very simplistic terms, which is what is delivery and what is acceptance, yeah, in a contract. And so this old contract law would have a situation where, let's say, um, there's an offer, so something is for sale, and from the seller, and now as a buyer you accept the offer, yeah. And so when you accept the offer, now you have to communicate your answer, and based on this acceptance, yeah, so the seller makes a promise to give you something, and the buyer accepts, and so now you have acceptance, and based on that you have a contract, yeah. And so a nice 100-year-old contract law would then talk about acceptance and modes of acceptance. And one of the modes would be, well, if you see an ad and you send the, your acceptance in a contractual form, or with money or whatever, by a letter. And then when the letter reaches the buyer and the buyer opens the letter and sees your contract or whatever, then you have acceptance. All right, in a very simplistic way. And then of course, if you can intercept this letter before it reaches the buyer and you tear the letter, then there is no acceptance. Now, how would that work in the email era? Yeah, so you see an ad and it says for sale, and you write an email and you click enter, and now the email has gone to the other side in a matter of a few seconds. Now, this is very different from a postal way of dealing with things. And so the stupid way of tackling this would be to change the old law and to say that acceptance is by post or by email. Maybe a more better idea would be to have a digital framework for the new digital technologies that exist, and so electronic forms of communication and things like that. So of course there's always this problem with how much can you amend the old law vis-a-vis maybe, yeah, just forget it and introduce a new law, and so problem solved. And so this has happened, of course, with trademark law as well. So it deals with all these aspects. Now remember, it's a directive. It harmonizes the various member states and their EU laws on trademarks. Yeah. Um, there's also the community trademarks regulation. We're not dealing with that over here. It's more or less like the directive, but it deals with a community trademark. And then of course there are problems here now with Brexit, because what was earlier a community trademark, an English trademark, would now no longer be in the community, and so you have a lot of these issues coming up. Then of course you have other areas as well. There's conventions, so they have a lot of aspects. The Paris Convention spoke about well-known trademarks. Then you have the Madrid Protocol. I think there's a video on the Madrid Protocol so that you can see introduction to the Madrid system, international registration of trademarks. So something basic and simple, and you can now apply for a trademark. So you have basically different regimes. Let's say you are in Estonia or in Finland. In that case, you would apply for an Estonian trademark in Estonia or a Finnish trademark in Finland, and that's it. It only applies in those countries. That's the national system. Then you have a regional trademark, which could be a European Union wide trademark, and then under the regulation. And then you have maybe a global system, so you could just sit in Helsinki and apply for the trademark Hesburger all over the world. Yeah. Why would you do that? Well, you don't have a Hesburger in India or in China, but maybe you want to do that business, or maybe you want to stop competitors from using that trademark. So these are all important elements, and these are the procedures for getting trademark registration. And of course, why are they important? Well, I can tell you from personal experience, there was this, it's very often very tempting to just apply for a trademark internationally. Yeah, instead of going for countries one by one, you apply for the bigger picture. So there was this company, Estonia. They make Estonian pianos. Yeah, it's called Estonia Piano. And so they had applied for the trademark Estonia in Estonia, then in the European Union, and then in other countries, and now they wanted to apply for it in China. Now this is a few years ago. And in China, the law says that, well, you cannot have a trademark, which is the name of a country, uh, unless you can prove that in your own country, your trademark has been registered. Yeah. Now, well, they applied for the trademark Estonia in China, and they had to go through, with a business partner. And then they found out that the Chinese business partner was trying to cheat them and was trying to steal the trademark Estonia for the Chinese market. And so they went to court, and the court said, hey, I mean, we can't imagine how a country can give a piano company the name of the country as a trademark, because in Chinese law, you cannot have a trademark like China plane or China piano or China toy or something. Now, it's a countrywide legal thing, whatever. So if these people had a Madrid Convention application protocol thing, Madrid Protocol registration, or an EU community trademark, then by itself that would have been quite problematic. But because thankfully they had an Estonian trademark under Estonian law, which said that yes, the trademark Estonia for piano belongs to this company. So they were able to prove their case in China, and so they got the trademark back from their business partner who was trying to steal it. So these are again experience things, right? As a lawyer, you have to be able to explain to your client in detail that, look, what are the pros and cons of applying for a trademark, because your client wants to save money, but at the same time wants proper legal advice, and that's why the client comes to a professional. And so you have to be able to tell your client the good, the bad, the ugly side of everything. And based on your discussion, then your client can make a seasoned, reasonable, clever, smart approach. And that's what you do as a professional. So what does a trademark do in a sense? Well, it's a badge of origin, source, or the trade origin. And it also talks about quality, advertising function, descriptive function. And basically it helps, so let's say there are two products in the market, both are the same, and well, in this case there's not much of a difference at all. So what would make this better than this? Or one is this and one is this. So in this case you have a spring loaded thing, and this is more old school. All right. And so of course you want to you have, this is your product, this is your competitor's product, everybody out there. So basically you're trying to come up with a way of distinguishing your product from your business rivals' products. Yeah, that's basically it. That's what a trademark does, and that's the main function. Of course, a trademark can reveal a lot of things about you. If you like BMW or Mercedes, it's not just because you like that car, but it's because you like that German technology thing. Yeah, it means you want a car that is strong, does the job, looks attractive, is reliable, things like that. If you are the type of person who likes a Ferrari or a Maserati, which can go 300 miles per hour, well, you're stylish, you like to show off, you're not realistic, because whether you have a Ferrari or a Lada, you travel at the same maximum speed, so in Estonia or in Finland. So this is not the Autobahn in Germany, where you can go at 400 kilometers per hour or something. So a lot of the things about a trademark are quite simplistic. They tell you a lot about their product immediately. Same goes with cognac or champagne. Yeah, champagne is not the same as bubbling wine or whatever. All right. So all of these are very important elements about a trademark. So let's stop here for today. I really went on and on. And next week we'll look at the legal definitions of a trademark and what is acceptable and not acceptable as a trademark based on the directive. So until then, have a nice time, have a nice weekend, and see you next week.